Welcome to those of you who have dialed in, and welcome to those of you who I can see are continuing to dial in. My name's Tony Hadden. I'm the head of the employment team here at Brodie's, and I'm joined today by Isobel Dinverno, who is our Director of Corporate Tax and is unusually for our employment team's webinars an accountant. But Isobel is the convener of the Law Society's tax committee and has very close links with HMRC, and we thought it would be very useful for her to come on to help guide us through the claims process and the actual portal that HMRC put up on their website on Monday. So what I'm really saying is any difficult questions or any questions to do with numbers, can you direct them to Isobel? Other questions I can probably handle. What we're going to focus on today, we're going to have a look at the portal. Some of you, I'm sure, will have already had the joy of working through the portal, but Isobel will talk us through that portal and the claims process to allow your organisations to claim furlough pay under the Coronavirus Job Retention Scheme. I'll then have a look at the Treasury Direction, which is this new administrative legal beast that all employment lawyers and HR professionals are dealing with. And we'll also have a look at the many iterations of the HMRC guidance and how the combination of those two things results in clarity or confusion in relation to some of the topics that I know we're all trying to grapple with as we try and manage workforces. We'll finish with some other issues that remain confused. I can see that some of you have already found the chat function. I should warn you that the chat function is open, so if you post something on the chat function, everybody can see it. We would like you, as we go along, to ask questions, but given the numbers, we can't take questions in oral form. So if you do have a question, there will be some time at the end where we will try to answer some questions using the Q&A tab. Somebody's raised their hand. I don't know what that means, but if you have a technical problem, maybe you could put your comment in the chat function and one of our behind the scenes tech wizards will try to help you. I can't, so I'm just going to plow on. The first part of the session will be Isobel talking you through the portal and the claims process.
Thanks, Tony. The figures for the portal up to the end of the second day were that 2.2 million employees had been claimed for, and the overall claim amount was 2.6 billion. So that just is an indication of how quickly people are being able to make claims. And the portal is working so far, the front end anyway, is working well. And if that's a quote from Rishi Sunak, the Chancellor, saying, you know, at times like this, the state has got to actually get involved and try and sort things out. And they're doing the very best that they can. We've had a question about whether the slides are going to be made available. There will be a recording made available after the session. So, you know, you'll have that to look at. But we've also had a claim about when you can make the first claim under the portal, and you don't need to wait until the initial furlough 3-week period is complete. You can go ahead and claim already. And in fact, if you want to get the money by your payroll date, you may just be able to squeeze it through if you made a claim today, because the claims are being paid within 6 days. That's what the revenues timescale is at the minute. Before you go on to make a claim, there is quite a bit of preparation that you need to do, because the process is not one where you can go in, start the form, and then go back out again and come back later. Sorry, we can just go back to the previous slide. The process is that you have to, if you've got more than 100 employees, put in a spreadsheet for them. But if you've got less than 100 employees, you have to put them in individually. So you have to have all the information kind of ready before you start, and you need to have worked out the amounts and so on and so forth. You need to look at this guidance, Claim for Your Employees' Wages, which has got a red front on it. And there's an HMRC web page as well, which is a step-by-step guide to how to do it. So if we move on to the next slide now, to be able to make a claim, you have to have a payroll that was in existence by the 19th of March, but you also need to have a government gateway ID and password. So if you haven't got that, you need to apply online for it. And that's the first link that's on this slide. You also need to be enrolled to make PAYE returns online. And if you haven't got that, you can apply now. And the revenue have speeded up the process. You used to be able to, or used to have to wait till you've got a sort of registration number through the post. They've taken that step out, so it'll be much quicker now. But you do need to have these things before you can make a claim. So moving on to what the employee requirements are, employees that you're claiming for need to have been on the payroll on or before the 19th of March, but you actually have to have also made a payment to them. So you need to have made an RTI submission, real-time information submission, to HMRC on or before the 19th of March. So you need to effectively have paid them. So that 19th of March figure is a bit misleading. They also need to have been furloughed. And so there needs to be a furlough agreement, and that's obviously not something that tax folk should be engaging in, and Tony will talk about that afterwards. So as far as the employees go, those are the sort of broad requirements. So moving on to the periods, the furlough scheme at the minute spreads from 1st of March 2020 to 30th of June 2020. You can furlough people for a minimum 3-week period, but that is only a minimum. You can furlough them for longer. You can furlough people more than once, and you can furlough people in rotation. So you can make claims. If you've furloughed people for a 3-week period, you can make a claim for that 3-week period. Or if it's longer, you can kind of make one claim a month to tie in with your payroll. And that's how HMRC are expecting it to work. Looking at some other points, how much can you claim? Obviously, working it out is important and perhaps slightly tricky. It's 80% of salary or 2,500 a month plus NIC. And if you do top up your employee salary, then you can only claim for the NIC on the sort of 80% or 2,500. You can't claim it on the top up amount. And there's some points about whether you're actually paying NIC and deducting the employment allowance first before you work it out. You can also claim pension, but both the NIC and the pension are slightly convoluted. So if we look at the next slide, it should have the NIC amounts on it. So you need to start with the grant you're claiming and then deduct the sort of NI limits and then multiply that amount by 13.8. If you are deducting employment allowance, then you would deduct the employment allowance first before you calculate the NIC. So some people are saying it might be worth not claiming employment allowance at the minute and leaving it till later in the year when all of the furloughing and so on is over. Moving on to the pensions, you again start with the amount that you are claiming for the employee's wages and then deduct the sort of threshold for employer pension contributions, and then multiply that by 3%. But you can only claim if you are actually making pension contributions. So if you're making contributions and they're less than this, it's the amount that you're actually paying that you can claim. So the guidance says that you'll be thrown out of the system after 30 minutes inactivity, but people are reporting that it's less than that. So it's like 15 minutes inactivity. That's why you have to be prepared in advance. And again, as we've mentioned, more than 100 employees at the moment, you have to enter them individually, but you can upload a spreadsheet if there's more. What if you don't have the national insurance number for a particular employee? Well, if you're in the situation of having more than 100 employees, you can put a payroll number on your spreadsheet and that'll be fine. But if you're putting them in one by one, then you do need NI numbers. And if you don't have them, the alternative is to actually phone HMRC on the COVID helpline, and they will be able to take your claim by phone. So that's the latest guidance on that. There's one part of the form where it keeps asking for UTRNs or corporation tax reference numbers or things like that. If you don't have any of those, just keep saying no. And eventually it'll say what's the organisation's name, and then you can put in the employer's name and you'll be able to do the submission. And a couple of other sort of oddities. There's a bit which asks for the address associated with this bank account. And there's been a bit of toing and froing about what address that is. HMRC have confirmed that they mean the taxpayer's address, i.e. the address where the bank statements go for that bank account. So it's not the bank's address, it's the taxpayer's address. The other slight embuggerance factor is that the HMRC calculator, which you can use to try and calculate your 80%, uses calendar days, whereas most payrolls use working days. And HMRC have confirmed that when you're working out your figures for the claim, you can just use whatever your payroll uses. So the HMRC calculations are indicative. They're not saying you can only do it on this basis and you've got to, the amounts that you can claim are reduced. At the end of the process, you have to sign this declaration, which is worth having a look at, because you're saying that you're making the claim in accordance with HMRC's published guidance. So that's reiterating that you need to have read the guidance before you do it. It's correct and complete and so on and so forth. All employees have been paid or will be paid in the next payroll. And that's the point about they're expecting it to be done sort of in time for payrolls and so on. And you can amend the claim if any of the information changes. And obviously HMRC have an audit process that they may take up afterwards to check the details. Once you've submitted it, please be aware that they won't be issuing an email confirmation. So you should print out, if you can, the submission record or reference number, or take a screenshot or take a picture on your camera or whatever it is. So that's the practical aspects of the portal. I'll hand back to Tony now to talk about the Treasury Directions and revised guidance.
Yeah, thanks, Isobel. Reaffirming a lot of my life choices about why I didn't become an accountant, because those number calculations look complicated, but good luck for anyone listening who has to go through all that. I'm going to turn to what in normal times would be, for me at least, more comfortable territory, which is the law surrounding this. I've put up on that slide how we got to where we are now. Less than a month ago, the Coronavirus Act, which was the piece of legislation that started all these strange new powers that our different governments have, was given royal assent. HMRC were quick off the mark, and they published some guidance about the job retention scheme on the 26th of March. You probably remember that there were lots of issues raised by HR practitioners, lawyers, accountants, and all sorts of people. And HMRC listened to a lot of that and updated their guidance on the 4th of April. There were then a lot of comments from HR practitioners and employment lawyers and accountants. So they updated their guidance again on the 9th of April. There were then a lot of comments from employment lawyers, HR practitioners, and accountants. So they updated their guidance again on the 15th of April. And at the same time, the Treasury issued a direction on the 15th of April. Then there were even more questions and comments, so there was more guidance issued on the 17th of April, and the portal, as we know, opened on Monday, and yet more guidance was issued at that point. So in fact, when Isobel says be aware of the guidance, there is quite a lot of different iterations of the guidance, and we've also got this Treasury Direction, and lots of people, particularly in the employment law world, are exercising themselves about how to read the Treasury Direction alongside the different iterations of the guidance. And the reason I've put on the slide that that is exercising us as employment lawyers is because the guidance that HMRC has issued is not always 100% consistent with the contents of the direction. Having spoken to our administrative law team, who are one of the best administrative law teams in the country, I asked them how I should describe the Treasury Direction, and particularly whether I should say whether it's law or not. And the best that we could come up with is to say that it is an administrative ministerial direction. I think what that means is that in strict legal terms, the Treasury Direction tells HMRC what it should do. So HMRC can't act in a way that is inconsistent with that direction. But we know that HMRC are going to be responsible for administering the scheme. They're going to be responsible for issuing the money, and they're also going to be responsible for deciding how, when, and if to audit applications to the scheme. And in circumstances where that is the case, we think that relying on HMRC guidance, and particularly guidance which HMRC has issued which post-dates the direction, is likely to be the most sensible route for a business which is faced with taking a judgment call between the contents of the Treasury Direction and the contents of the guidance. It may be that there are lots of exciting administrative law cases about any conflict there, but we think that provided you've followed particularly post Treasury Direction guidance from HMRC and use that as the basis for your judgment, that's probably the safest route. So looking at some of the areas then that all this different guidance and the Treasury Direction have tried to address, one of the things that we were all very concerned about during the first few iterations of the guidance was how to treat holidays. I think it's now clear that holidays continue to accrue during the furlough period. Employees are entitled to take holiday while the furlough period is running, and that doesn't break the furlough period. So that 3-week period isn't broken just because, for example, Good Friday or Easter Monday fell in the middle of it, or in fact, other holidays. What is still not entirely clear is whether employers can require employees to take holidays. If I was forced to give a view on that, I would say I think it's more likely than not that employers can, but there are all sorts of issues about whether employees would be able to have rest if the employer was imposing the holiday on them as opposed to them choosing it. What we also know is that during the holiday period, employees must be paid 100% of what I've described there as their normal holiday pay, and all of us who've been involved in HR over the last few years know that that is not always a straightforward thing to work out. So all the working time regulation stuff, all the overtime stuff, all the stuff that applies to holidays, that's all bound up in that. But we know that you can't, during the furlough period, pay employees just the furlough pay. You have to pay them their normal holiday pay for any holiday they take. Bank holidays depends on whether that is a holiday, if you like, or whether, as in many businesses, there's a need for cover, and so the individual chooses whether to take it as a holiday or not. Arrangements, unhelpfully, the direction made a number within it which suggested that in order to document the furlough arrangement and therefore be eligible to make an application for the grant, you needed the individual employee to agree in writing. Post the Treasury Direction, HMRC guidance has said that the employer must confirm the arrangements in writing, and that makes sense because most people would be wanting to set out what has happened, and that was always the case, that we had to set out in writing what the arrangements were. But HMRC post the direction have explicitly said the employee does not have to provide a written response. Bear in mind that the HMRC guidance only relates to qualifying for the grant. It doesn't relate at all to the need to document and potentially agree the contractual arrangement you have with your employee. So that's why we said on the slide that in practice, the best approach, even if you don't feel as if you're amending the contract, because perhaps you're topping up to 100% and you feel you have the ability to require the employee not to come to the workplace, even if that was the case, we think the best approach is to try to seek some form of positive response from the employee. The reason why this is so difficult is because at the very beginning, lots of employers were in a position where they simply had to ask lots of people to stay at home, and it wasn't practically possible to wait for a positive response from each employee before implementing those arrangements. So we think you should still be trying to get agreement, but if you haven't, we think you can still make the application on the basis of that HMRC guidance, subject to the caveats I've set out before. Another thing we thought was pretty clear, but is unfortunately becoming less clear, is the position of those who are sick. The HMRC guidance and the arrangements that the government's put in place in relation to statutory sick pay, allowing the reimbursement of statutory sick pay for smaller employers, those we can all understand. The point of the furlough scheme is not to reimburse sick benefits, but where an employer is faced with a group of employees who all have to be furloughed, it seemed difficult that you could furlough everybody apart from those people who were off sick. HMRC had previously said that where there was a group of employees, you could still furlough them even if some of them were sick. But the Treasury Direction says that you can't access the furlough scheme for a period where the individual is entitled to statutory sick pay. So if you are furloughing people and they are eligible for statutory sick pay, the best thing we think to do is to either wait till the period of sickness ends, or to specifically indicate that they are no longer sick, they are now furloughed. But there is that issue now that's been brought in through the Treasury Direction that those who are sick are not in as easy a position as they were before. Maybe we can move, 0 hours workers, contingent workers, agency workers, HMRC, and the scheme and all the accompanying commentary was always quite clear that those who were employed not on what we might think of as more traditional contracts, that those people would benefit from the job retention scheme. Is intended to support people. The Treasury Direction does cast some doubt as to whether those casual workers would be able to claim. We think that given that there are calculation mechanisms for those with irregular hours, that subject to all the other issues about furloughing 0 hours workers, we think that the Treasury the revenue guidance is probably preferable to an assessment that says you can't furlough 0 hours contracts workers. Those whose work was tailing off prior to coronavirus, the issue of how much you furlough them at, that is very difficult. And if someone worked a lot in January, but not at all in February, and you furloughed them at their January income, we think that could produce quite difficult problems, because it's clear that the reduction was not because of COVID, but was for some other reason. I'm conscious of time, so moving on to other issues that remain confused. In case you hadn't realized, the answer to the question that was posed in the title of the seminar, is confusion over? The answer to that is unfortunately not. In terms of other areas that are confused that we think should be answered soon, The ones that I will deal with, employee representatives and furlough. So this is where you have an event during the furlough period, either a redundancy or a TUPE transfer, which requires you to elect employee reps. What do those employee reps earn during the period when they're acting as reps, and does their acting as reps break that furlough period and so mean that you can't claim for that period of time? We think the answer to that is that it does not break the furlough period, and we think the answer is they don't earn anything other than their furlough pay. And we hope that there will be clarification from HMRC or the government on that soon. The rationale being that the work, inverted commas, that they're doing is not work that benefits the employer, it's actually technically work that benefits their fellow employees, so it's more akin to volunteering. The other point in the purple lens and the mustard lens, this is about the conditionality of some furlough arrangements. So lots of employers said, we will furlough you, we want you to agree that your pay is varied so that you do not receive any pay unless and or until we receive money from HMRC. The Treasury Direction suggests that that might prejudice the recoverability of the grant, because the grant is supposed to be a reimbursement of salary which is committed to the employee. So can wages be deferred until the scheme funds are received? We think probably yes, without prejudicing the grant. Can wages be varied so that they are only entitled to wages if the grant is given? There is slightly more debate about that. Lots of employers have done that. Some of the cases in the insolvency area have dealt with employers who've had to do that, and there hasn't been adverse comment from the bench, from the judges in those cases about doing that. So we think the answer to that is probably yes, but if you can, it's safer probably not to do that and then make the grant application as a reimbursement. Isobel's going to talk briefly about salary sacrifice and pensions, and then we'll take a couple of questions before we finish.
Okay, so on salary sacrifice, when you're working out the sort of reference pay and so on, you don't take the salary, or you can't use the higher salary before the salary sacrifice. You have to base it on the net salary after some has been sacrificed. And in terms of the payments from the government scheme, you can't use those to fund salary sacrifice. So if it's 2,500 a month that you're claiming, you've got to pay all that over in cash. So if you want to incorporate salary sacrifice, you need to do a bit of grossing up and figuring it out to get the right effect. On pensions, it's really just, we talked about how you calculate what you can claim, but there is another side to it, which is how your normal company scheme might work and what contributions you might have to work given these variations to contracts and so on. That's a bit of a different topic, and our pensions team have just published a blog about it. So I'll say no more about it just now, but it's just to bear in mind there are two different sides of pensions, as indeed other things. Tony.
Great. So just looking at the questions, we're not going to have time to deal with them all, but one of them is for you, Isobel. What about employers with UK employees but who do not have a UK bank account, so bank accounts based in Guernsey, Jersey, or offshore?
Unfortunately, they've got a problem at the minute. There isn't a solution. You have to have a UK bank account to receive money under this scheme. HMRC are working on a solution, but it isn't here yet. So it's a sort of watch this space
Cool.
on that.
I've had a question in, and I will answer this question because this person's been brave enough to put their name on their question. So this is a question from Graham Ross. With the oil price being low, could HMRC question businesses in the oil industry furloughing people, claiming this is connected to loss of business due to COVID rather than the oil price? I think the answer to that question is yes, and I think HMRC have made statements about being alive to abuse of the scheme. The name of the scheme is the Coronavirus Job Retention Scheme, and I think that in order for you to be safe from an allegation that you're abusing the scheme, you need to make the grant application on the basis that you at least have the possibility of retaining that job in your business. If you're in a position where you know now that you can't retain that job in your business, then I think the scheme is not available to you. How anyone, though, could have any certainty about what the next month will bring, 2 months will bring, I think there's a different question there. And particularly, Graham, I assume you work in the oil industry. It's such a volatile world at the moment that I think it would be possible for employers to quite legitimately say, I don't know what's going to happen, and therefore it may be the case that the whole world changes, the oil price shoots up again, and in those circumstances I would be able to retain these jobs, so therefore I am going to access the scheme. So uncertainty works both ways, but I do think if you know that job is going, this scheme is not designed to compensate you for your redundancy liabilities. A great question. So everyone's putting their name in now so they get their questions up. Elizabeth Brown's asked a question: is an employee obliged to let their employer know if they become sick during furlough? That is a brilliant question. And given the complications around statutory sick pay and that issue about whether you're potentially not entitled to your furlough pay if you are sick, it may be that it's not in anyone's best interest to let their employer know if they become sick during furlough. So that might be something that you address in your furlough letters. Final question. Everyone's put their name in, so apologies to those we're not going to get to, but we are slightly over time. This is a question from Jackie Taylor. We have an organisation that is an alio of a local authority. Is there any restriction in furloughing staff from this organisation? And that question, I think, Jackie, is based on the indications that those organisations that are in receipt of public funds shouldn't be accessing the job retention scheme. We are aware as a firm that a number of businesses that are sort of hybrid businesses, so not quite public sector, not private sector, so some in-between type businesses, NDPBs and others, which have a mix of funding, have actually applied for specific permission to access the furlough scheme and have had that permission granted. So it may be worth you or anyone else in that position writing to those who are providing you with public funds looking for permission to access the furlough scheme, because we do know that that has been granted before. It's 14:33. One of the great benefits of a webinar is that we're in control of the timing, and I know from attending webinars myself that one of the best things you can do is finish on time. So I am sorry that we don't have time for any more questions, but thank you very much for attending. We will, as was indicated by Isobel, making up for my lack of housekeeping at the beginning, we will circulate a recording of this session to those who signed up to attend, and the slides will also be available. If you do have any questions that we can answer, please feel free to reach out to us. We both have large teams sitting behind us, but thank you very much for attending, and hope to see you at the next one of these webinars.